we will share a report of the event with you within the coming weeks. So first of all, I'd like to introduce Michael Lynk. Professor Michael Lynk is the UN Special Rapporteur for Human Rights in the Palestinian territories occupied since 1967. He's also an Associate Professor of Law at Western University in London, Ontario in Canada. I encourage you as well to read Michael's reports for the UN, which can be found on the website of the UN Human Rights Council. Michael, in his presentation now, will discuss accountability in the context of international law, and will look to his upcoming report to the UN on settlements. Michael, over to you.
Thank you very much, Eamonn, for that introduction, and my grateful thanks to Sadaka for the opportunity to speak today. I'm hoping that my slideshow has been put up. Great. I'm particularly honored to be able to speak to these Irish and EU parliamentarians today in the wake of the Irish Parliament's adoption of the anti-annexation resolution in May. What a great step forward. Martin Luther King Jr. once famously said that the arc of history is long, but it bends towards justice, to which the Reverend Jesse Jackson importantly added, but you have to make it bend. It doesn't do it by itself. By adopting this anti-annexation resolution, you have made the arc of history bend just a little bit more towards justice. So I'm having trouble moving this forward. There we go. Okay, I'm sorry. Just let me try once again with the slideshow. My apologies for that. There is a growing realization that the reality of the Israeli occupation is getting worse, and that the traditional approach of the international community to hope that Israel is going to change its behavior by itself, willingly and voluntarily, is a dead end. Last week, former UN Secretary General Ban Ki-moon published a remarkable op-ed in the Financial Times. I urge you to find the entire op-ed. It's only a 4 or 5 minute read. But here he says, obviously, he points out the fact that Israel has been pursuing this incremental de facto annexation since the occupation in 1967, to the point where he says the prospect of a two-state solution has all but vanished. And he goes on to say, the reason why this is happening is because there's an utter lack of any international legal accountability, which only encourages Israel to go on to define UN resolutions and international law. In particular, he points out that it's been defined Security Council Resolution 2334 from 2016, that the settlements violate international law. So I want to first speak very briefly to the legal status of the Israeli settlements. There are approximately something close to 300 settlements in the occupied territory and the West Bank, with approximately 680,000 Israeli settlers in there, and it grows by around 20 to 25,000 settlers per year. The settlements are the engine of the occupation, and they're Exhibit A in Israel's two goals of declaring sovereignty over East Jerusalem and much of the West Bank, and to prevent the creation of a genuine Palestinian state. International law is very clear with respect to this. I point you to the Fourth Geneva Convention of 1949, which is the leading text with respect to international humanitarian law and the laws of war. Article 49.6 very clearly says that the occupying power cannot deport or transfer parts of its own civilian population into the territory it occupies. This is Resolution 2334, which Ban Ki-moon made mention of, where it says that the settlements have no legal validity and constitute a flagrant violation under international law. And then we have Article 8.2b little 8 from the Rome Statute of 1998, which created the International Criminal Court, which says that the transfer, directly or indirectly by the occupying power, of parts of its own civilian population into the territory it occupies now meets the definition of war crime. And I'd like to point out that both the Fourth Geneva Convention and the Rome Statute are not only integral parts of international law, they're parts of Irish law as well. Ireland adopted the Fourth Geneva Convention in the Geneva Conventions Act in 1962, and it adopted the Rome Statute into Irish law by the International Criminal Court Act of 2006. And this is the exact same wording from the Rome Statute, which is incorporated into Irish law through the Criminal Court Act of 2006, which gives a very broad definition and then surely captures the fact of what Israel has been doing. And I must point out my new UN report, which will be delivered tomorrow to the Human Rights Council, actually addresses the question of whether the Israeli settlements are a violation of the war crimes prohibition under the Rome Statute. And I'll let you guess by having to read the report as to what I finally say with respect to this. I want to now turn to the question of annexation, which obviously was at the heart of the resolution from the Dáils in May. Annexation is one of the clearest prohibitions in modern international law. It was solidified in international law by Article 2 of the Charter of the United Nations in 1945. And this was because the world had come to recognize that allowing countries to militarily expand their borders and to conquer other lands was the leading cause of international instability, and it had been the root of both World War I and World War II. And the best way of ending the destabilization of the international system was banning the ability of countries to be able to annex and conquer lands. You see this in the lead resolution from the UN Security Council in 1967, Resolution 242, which is the first of dozens of resolutions that the Security Council has passed on the Israeli-Palestinian conflict over the past 54 years, where it says it emphasizes the inadmissibility of the acquisition of territory by war. And I'll come back to this in a few minutes. And I point out at the bottom of the slide that annexation is now a crime of aggression, a violation of the Rome Statute under the 2010 Kampala amendments to the Rome Statute. And I understand that Ireland has actually adopted the 2010 amendments to the Rome Statute into its domestic law as well, through amendments to the International Criminal Court Act of 2006. So this is both an integral foundation of international law as well as a cornerstone of Irish international criminal law as well. Now, with respect to the issue of accountability, I often raise this issue because my point has been in the last probably 3 or 4 years of my reports is that while Israel's annexation and its settlements are clearly and absolutely prohibited by an authoritative and frequently stated body of international law, the international community has been remarkably reluctant to want to enforce these laws. Just let me point out to you where the main issues of non-compliance has been. And this is not, I'm not simply talking about the hundreds of resolutions coming from the General Assembly or the dozens of resolutions coming from the UN Human Rights Council on annexation, settlements, and the application of international humanitarian law to the occupation. I'm talking about Security Council resolutions. The UN Security Council, as I'm sure all of you are aware because of your Ireland's current rotating seat on the Security Council, the Security Council is the highest deliberative body in our international system. And you can see here where in these 3 main areas, the Security Council has adopted 22 resolutions since 1967, stating that the Fourth Geneva Convention, the protection of civilians in time of armed conflict, applies in full to the occupied Palestinian territory, to East Jerusalem, the West Bank, and Gaza. With respect to annexation, the Security Council has adopted 11 resolutions, which state in one form or another that the acquisition of territory by war or by force is inadmissible, all of them with specific reference to Israel's occupation and its annexation of East Jerusalem and its annexation of the Syrian Golan Heights. And with respect to the settlements, the Security Council has adopted 7 resolutions beginning in the early 1970s, stating that Israel's settlements are illegal, that they're a flagrant violation under international law, and that Israel's attempts to demographically change the population structure of the occupied territories is a grave breach of international law. None of these resolutions have been obeyed by Israel. Israel is in defiance of I think in a total of about 31 Security Council resolutions since the early 1970s. As the very brave and courageous Israeli columnist Gideon Levy, who writes for Haaretz, has said, no country is as dependent on the support of the international community as Israel, yet Israel allows itself to defy the world as few dare. So what does international law wind up saying with respect to accountability? These are the leading provisions with respect to accountability. There are others, but these are the 3 cornerstones. With respect to Common Article 1 of the 4th Geneva Convention, the 4 Geneva Conventions of 1949, each of the 4 Geneva Conventions says the high contracting parties undertake to respect, but also to ensure respect for the present convention in all of its terms. And as I point out there, that's also Irish law through the Geneva Conventions Act of 1962. The 4 Geneva Conventions are among the most ratified and adopted of international agreements in the modern world. 194 signatories act as the high contracting parties to this. So this has universal application. Secondly, the 2001 Articles on State Responsibility, which was adopted unanimously by the UN General Assembly in 2001, and which are now part of customary international law. Articles 40 and 41 of these articles say that states shall cooperate to bring to an end, through lawful means, any serious breach of general international law, and no country shall recognize as lawful a situation caused by a serious breach. And thirdly, is a cornerstone of the international legal system. Article 25 of the Charter of the United Nations says, as you can see, that members of the UN agree to accept and to carry out the decisions of the Security Council in compliance in accordance with the Charter. Israel has a solemn duty as a UN member state to obey UN Security Council resolutions that have been directed at it. And yet it is in defiance, as I said, of these several dozen resolutions without any consequences, without any cost for its defiance and for its continuation of its disobedience. This is one of my last slides, and I'm sorry for the dense text, but I'm sure that if you'll have time to read it, perhaps at your leisure afterwards. The International Committee of the Red Cross is among the most respected, among the most mainstream, and among the most influential of international humanitarian organizations in the world. Because of its vital role as the primary interpreter of the Geneva Conventions, it has developed a rich body of accountability measures that it recommends that the high contracting parties to the Geneva Conventions apply if one or more member states finds itself in defiance of or in breach of the Geneva Conventions and international humanitarian law. And I've listed just a couple of the accountability measures which the International Committee has actually recommended and says this is part of the broad, rich menu that countries, high contracting parties, are able to apply most effectively, obviously, in common and in unison to a country that is in defiance of international humanitarian law. You can see some of them I underlined: the non-renewal of trade privileges or trade and investment agreements, arms embargoes, trade and financial agreements, limiting arms and transfers, referring matters to the Security Council or the General Assembly or the International Court of Justice, or I would recommend the International Criminal Court. And you can see that there's also, it suggests the resorting to penal measures to repress violations of humanitarian law. And as well, it urges the support of both national and international measures to bring suspected perpetrators of serious violations to justice who are in violation of international humanitarian law. So there's this rich body of menu of accountability measures, which the world, paradoxically, it doesn't seem to want to be able to want to apply. As rich and as well articulated as the international law which applies to the Israeli occupation has been, there's a virtual dearth on the other side of the human rights ledger, trying to bring some kind of accountability to Israeli action. And to my last slide here, I know that there's been a significant amount of attention paid over the past month with respect to the fact that there's been a change of government in Israel and that there is an early honeymoon that this government is enjoying internationally. I have to say that while there is a new Israeli government in power, there is no new Israeli policy with respect to the settlements or with respect to annexation. And I'm quoting here from Prime Minister Naftali Bennett's speech to the Israeli Knesset upon being sworn in as Prime Minister. And he says, you'll see the first quote is, "We will strengthen the building of communities across the land of Israel." What he's saying is the land of Israel is the land that Israel controls between the Jordan River and the Mediterranean Sea, and that the settlement construction, the building of more housing units, the enticement of more Israelis and diaspora Jews to move to the almost 300 Israeli settlements will continue. And he says, we will also ensure Israel's national interest in Area C, which is the 60% of the West Bank that Israel fully controls militarily and security-wise, and we will increase standards to that end after much neglect in this area. So he's saying that we will continue, in fact, accelerate our building of settlements, settlement housing, and to ensure that they stay Israeli forever. Thanks very much for this. I think I'm at the end of my 15 minutes, and I'll be happy to answer questions later on.
Michael, thank you very much for that. That's incredibly interesting and useful, particularly when you talk about accountability measures and the articles on state responsibility, which fall to Ireland to act on, as they do on all other states. I think in particular, you very clearly outlined from the ICRC the kind of measures that can and should be taken in the context of annexation and in the context of occupation. So we look forward to questions to you later on. So we'll move on to our second speaker, and that's Dr. Susan Power. Susan is the head of Legal Research and Advocacy with Al-Haq, the leading Palestinian human rights organization. Susan is an expert on many aspects of international law. She's an expert on business and human rights, the laws of armed conflict, and international criminal law. She has published widely in academic journals and has presented as well before many international organizations, including the ICC and others. And as well as all of that, Susan is a board member of Sadaka, the Ireland Palestine Alliance. So Susan will talk to us today about EU law and practice concerning countermeasures in the context of de facto and de jure annexation. Susan.
Thank you, Eamonn. Thank you for inviting me to speak to this very distinguished audience on annexation implications and the consequences panel. So we have arrived now at a very critical juncture of de facto annexation, where Ireland has declared that Israel's actions amount to an unlawful de facto annexation of the territory. And at this point, we really need to assess what are the adequate countermeasures that can be taken, especially in light of the failures of the international community to respond adequately to the annexations of East Jerusalem and of the occupied Syrian Golan previously. So as a starting point, we can note briefly the illegality of annexation as an internationally wrongful act, and an act for which there is both state and individual criminal responsibility. And then we'll examine the adequate countermeasures to collectively push for. So the acquisition of territory through use of force is a violation of the law's jus ad bellum. Annexation comprises of two elements. So we have the occupation of territory, along with an intention or an animus to permanently appropriate the territory. So in this respect, we can say that much of the West Bank has already been de facto annexed. And the annexation of territory in particular violates Article 2.4 of the UN Charter, which prohibits not only war, but also the threat or use of force against the territorial integrity or political independence of any state. And so it is also important to note that annexation, as previously mentioned by Professor Lynk, is an act of the crime of aggression. So it incurs individual criminal liability under Article 8 bis of the Rome Statute of the International Criminal Court. So it is one of the most serious crimes in the international legal order. So here we have, but we can still push for third states to collectively implement individual sanctions as well as state sanctions, given the gravity of the crime. So here we need to engage third states' responsibility in particular, noting that measures of annexation constitute internationally wrongful acts from which no rights can be derived. The obligation by third states when addressing a serious breach is to not render aid or assistance to the responsible state in maintaining the situation so created, and for the states to cooperate to bring the unlawful situation to an end. So with that brief backgrounder on the illegality of annexation, individual criminal responsibility and state responsibility, we'll now look at what measures civil society have been calling for. And I suppose first, in terms of a very low-hanging fruit, is one of state recognition. So for states that have not already done so, to recognize the state of Palestine. And this is particularly useful in terms of Palestine's international legal personality in the international legal order, and for conducting state business and for accountability. And it also clearly raises a marker that Israel does not have sovereignty over Palestine. So it's an important first step. But in addition, there should be calls and pressures put on third states to clearly reject any externally imposed and unilateral political settlements which are often foisted on Palestine. And second, we'll come to kind of more of the in-depth part of our calls, and that is the call for countermeasures. So in this respect, we need third states to hold policymakers accountable. So our primary call is for economic and trade restrictions on Israel, on Israeli politicians, on senior military personnel, all to be the target of restrictions. There must be a penalty of this magnitude for annexation. So usually we would see sanctions applied at a UN Security Council level, but we can also call on UN member states to address the situation of de facto annexation in the occupied territory at a General Assembly level, specifically under a Uniting for Peace Resolution 377 procedure. So here the General Assembly must act in the face of an ongoing de facto or de jure annexation and implement measures to end Israel's military occupation and enable Palestinians to exercise their right to self-determination. And we can draw from precedent here. There has previously been a resolution from 1982 where the UN General Assembly adopted very strong language in Resolution 9.1. And there they found that all actions that were taken by Israel to give effect to its decision relating to annexation in the occupied Syrian Golan were illegal and invalid and would not be recognized. So it called on all member states to apply the following measures: to refrain from supplying Israel with any weapons and related equipment, and to suspend any military assistance which Israel receives from them. It also called on member states to refrain from acquiring any weapons or military equipment from Israel, and to suspend economic, financial, and technological assistance to and cooperation with Israel. And then finally, to sever diplomatic, trade, cultural relations with Israel. So the resolution also called on members to cease individually and collectively all their dealings with Israel and to isolate Israel in all fields. So it would be useful to work towards the adoption of a similar resolution in relation to Israel's annexation, de facto annexation of Palestine, of the West Bank. But I suppose a hurdle to overcome here is Ireland's policy on sanctioning Israel. So in the immediate aftermath of the annexation motion, the Irish ambassador to Tel Aviv ran a news article in the Jerusalem Post assuring Israelis that the Irish government opposes any form of sanctions or boycotts against Israelis or Israel. So again, this is kind of slightly contradictory to previous international measures which have been provided for under UN General Assembly Resolution 9.1 that could potentially be triggered in relation to the annexation of the occupied Syrian Golan. But separate to this, we need to specifically and also strategically call on the EU in a campaign to push for EU restrictions on Israel, very similar to the types of restrictions that we've seen previously that the EU has administered to Russia in Crimea. But we'll note here as well, just to start off, that under Articles 347 and 348 of the Treaty of the Functioning of the EU, a member state may also take measures on the grounds of national security and duly justified cases. So states can actually take unilateral sanctions where there is which basically cause the disruption of economic relations with a third country, or impose sanctions on third country persons where it is required for its national security, even when there's no council decision authorizing or requiring such sanctions. However, the latitude for unilateral sanctioning is quite narrow, and it is directly related to very serious internal disturbances which affect the maintenance of law and order, or also in the event of war, or where there's a serious international tension constituting a threat of war, or, and this is more important, in order to carry out obligations it has accepted for the purpose of maintaining international peace and security. So such measures like these would need to be consulted with other member states as well as the Commission. Again, this is all of a very exceptional nature and is generally interpreted quite strictly. But here we could possibly see a possibility of looking at measures like we'd seen before in relation to the Golan under General Assembly resolution, or also potentially maybe try to look at measures under the UN Commission of Inquiry recommendations. So we did have in 2019, under the recommendations of the UN Commission of Inquiry into the Great Return March, a recommendation under paragraph 127, where the Commission recommended that state parties of the United Nations consider imposing individual sanctions such as travel bans, asset freezes on those who had been identified as responsible for the commission of crimes during the Great Return March. And here the Commission had a list of perpetrators for these purposes. But I think what's interesting is that we also have a forthcoming Commission of Inquiry established by the UN Human Rights Council. And this is going to look at the root causes. So the root causes of the ongoing conflict, such as the colonization, the apartheid, and potentially de facto annexation. So there could be further opportunities here to have individuals listed on a particular sanctions list. And here we could have leeway again, perhaps under Articles 347 and 348 to potentially run with individual and sanctions in this regard. But in terms of EU sanctions, the EU outlines that sanctions are preventative measures. So they allow the EU to respond swiftly to political changes and developments that go against its objectives and values. So we usually see sanctions of this nature for acts of terrorism, for nuclear proliferation activities, for human rights violations, and importantly here for the annexation of foreign territory, and also for the deliberate destabilization of a sovereign country. And there are a number of types of restrictive measures that can be imposed. So there's diplomatic measures, we have individual restrictive measures. So these are, for example, assets freezes and travel restrictions. And there's also restrictions on economic relations, economic sanctions, and restrictions on economic cooperation. So far we've seen these types of restrictive measures on Iran, on North Korea, on Russia, and more recently, which was in the news, Belarus. For us, coming back to like March 2014, the types of restrictions that we saw against Russia in relation to the illegal annexation of Crimea were quite important. Especially as a comparative analysis. So in 2014, following Russia's annexation of Crimea, we saw immediately that there was a number of restrictive measures were taken. So the EU summit was cancelled, and EU member states decided not to hold bilateral summits. Our bilateral talks with Russia on visa matters and some of the new agreements that were going to be concluded between the EU and Russia were suspended. Instead of the G8 summit, Russia was dropped, and instead there was a G7 summit in Brussels. And then there was also the suspension of negotiations over Russia joining the Organization for the Economic Cooperation and Development and their joining of the International Energy Agency. So there was also a number of restrictive measures were applied. So these were against individuals and entities. So here it was for their role in the construction of a bridge and railway tracks, which had linked Russia to the illegally annexed Crimean Peninsula via the Kerch Strait. So this was seen to have isolated Crimea from the Ukraine. And even today, there's now currently 177 individuals and 48 entities on this individual restrictive measures list. But we have very similar acts in relation to the annexation of Palestine. There's acts of construction of settlement infrastructure, and also Israel has taken numerous actions which are consistent with permanency and with the claim of sovereignty over the area, including demographic changes and population transfers. We've seen the building of bypass roads and railway lines connecting settlements to Israel, and this is all inaccessible to Palestinians. So all of these individuals and corporations involved in acts such as these should really be made the subject of individual restrictive measures. And the other types of measures we saw play out in Russia were an import ban on goods from Crimea and Sevastopol into the EU. We saw restrictions on trade and investment related to economic sectors and infrastructure projects. We also saw a prohibition to supply tourism services to Crimea or Sevastopol, and an export ban for certain goods and technologies. And all these measures are still in place, and they're extended until June of next year. But what we're really seeing here is a clear double standard. So in Palestine, acts of de facto and de jure annexation of Jerusalem, for example, have been widely documented since 1967, and these have not been subject to any international countermeasures, even despite the additional obligations of the international community to protect the city as a corpus separatum. Meanwhile, Russia's annexation of Crimea was immediately received with countermeasures, and more recently we saw the EU place very swift sanctions on Belarus after a flight diversion to arrest a journalist from a Ryanair flight. But separate to these types of restrictions, there's also other measures that we could take in relation to Israel. So we do think that, especially under the EU, there could possibly be a freezing of the Horizon Europe 2021 to 2027 programme. But also separate to this, and at a minimum, we would call for the clauses under the Horizon Europe 21-27 programme to be broadened. So we'd like to see these clauses include companies and entities that have operations in the occupied territory. At the moment, the exclusion clauses only cover companies and entities that have their headquarters in the occupied territory. So we'd like to broaden this much more further out, and that's something that could be picked up on straight away. In addition, we'd like to see added the possibility of suspending the EU-Israel Association Agreement for violations of human rights and international humanitarian law. And thirdly, there is currently a project, it's called the Euro-Asia Interconnector. This project connects the electricity grids in Europe to Israel. So it's often referred to as an electricity highway in the Mediterranean Sea. So this interconnector is going to allow for a bidirectional transmission of electricity between Europe and Israel. So each region can be an exporter and an importer of electricity. So the Israel Electric Corporation, it's Israel's main electricity company. It's a publicly owned company. It's a member of the Euro-Asia Steering Committee, and it will operate the grid in Israel. So in the occupied West Bank, the Israel Electricity Company distributes electricity directly to illegal settlements such as Ariel and all other settlements across the West Bank. So the Euro-Asia Interconnector is essentially going to link Israel's illegal settlements in the occupied territory to Europe's electricity grid. So we would like to see the EU and European states act immediately to ensure that the Cyprus-Israel leg of the Euro-Asia Interconnector project is discontinued immediately. We would also like to see any further engagement on the East Mediterranean gas pipeline dropped in relation to Israel. So the East Mediterranean, this gas pipeline is a natural gas pipeline that will connect energy sources from Israel onto Cyprus and Greece and onto mainland Europe. And here the gas infrastructure linking this pipeline is maintained by a full violent naval blockade of Palestine's water, which is held under active conflict. And fishermen in Gaza who breach the arbitrary enclosed limits are shot at and killed. We also recall the killing of 10 civilians on the Mavi Marmara for a planned breach of the blockade some years ago. And further, in addition to this, Israel has already pillaged Palestinian natural gas resources in the gas fields and from the gas fields. So to conclude, really, we need to engage for a public awareness raising campaign in relation to de facto annexation. We'd like to see this led by Ireland because of Ireland's success with the annexation motion, and to really get other states to act collectively and to work together to push for UN resolutions, and for these resolutions to include economic and trade countermeasures, and also for regional intergovernmental organizations, in particular the EU, to place collective restrictive measures on Israel and Israeli policymakers and military personnel who have engaged in internationally wrongful criminal acts of annexation. So just in relation to some other, some other measures that potentially could be taken up as well, potentially it would be good for the high contracting parties to the Geneva Conventions to convene a conference to study the dismantling of the settlement enterprise and affirm the unlawful nature of the prolonged occupation. We also would like, similar to Professor Lynk, to see all states, including Ireland, fully cooperate with and publicly support the International Criminal Court and to prosecute domestically Israeli perpetrators of war crimes and crimes against humanity in the jurisdiction. We'd also call on Ireland to continue its support for the UN Relief Works Agency and to continue the annual update of the UN database on businesses. We'd also like to see some work towards an advisory opinion at the International Court of Justice on the illegality of the occupation and de facto annexation, and also looking at issues of apartheid, and for Ireland to make steps and strides in this direction and support Palestine. In terms of domestic measures in Ireland, of course, our number one priority always is the progression and adoption of the Occupied Territories Bill. But just to conclude, as Professor Michael Lynk has stated in his most recent report on settlements, Israeli settlements are the engine of this forever occupation and amount to a war crime, and that settler colonialism infringes the rights of the indigenous population to be free from racial and ethnic discrimination and apartheid. In recent days, we've seen in Jabal Bay, Israeli settlers establishing an unlawful outpost and appropriating Palestinian land. In Sheikh Jarrah, Batan al-Hawa, and Al-Bastan, Palestinians are facing imminent expulsion. In Lifta, Israel plans to demolish the homes of Palestinian refugees, erasing their history from the western part of the city of Jerusalem. In Hamza, Palestinians are enduring another round of demolitions facilitated by Israel's discriminatory planning regime. These Palestinian experiences are manifestations of the Palestinian struggle, a struggle against Israel's settler, colonial, and apartheid system imposed over the Palestinian people as a whole. The persistent failure of third states to hold Israel to account, including to adopt sanctions and to bring the illegal situation to an end, entails severe and far-reaching consequences for the efficacy of the international system and results in the permanent denial of the Palestinian people to self-determination. We must have commensurate penalties for the crime. There must be countermeasures for annexation. Thank you.
Thank you very much, Susan. That was a very rich and a very detailed description of all of the possible countermeasures, or possibly not all of them, but many of them at least, available to us as Ireland, as the European Union, and as the wider international community. And as you so eloquently outline it, the exceptionalism with which the international community treats Israel is shocking when you see it playing out in contrast to the kind of measures that can be so rapidly introduced against countries when there is the international will to do so. And clearly, in this case, up to now, that will has been extremely weak indeed. So just to say, for the benefit of the group, that obviously the report, Susan's contribution will be outlined in the report, and we will work with Susan to make sure that there is an elaboration within the report of the measures that she has talked about here, so that when you come back for the new political term in the autumn, that there will be quite an amount of detail available to you for your own discussions within your parties. So finally, I'll now turn to our third speaker, Maha Abdallah. Maha is based in Brussels. She is an international advocacy officer with the Cairo Institute for Human Rights Studies. Her work focuses on corporate accountability in particular, in occupied territory, such as the Palestinian occupied territory, and in conflict-affected settings. Maha was elected to the board of the International Network for Economic, Social and Cultural Rights in 2018. And today for us, Maha will look at international countermeasures. She will look particularly at the UN database of companies, which was prepared last year, which identified companies operating in and benefiting from Israel's occupation of Palestinian territory. And she will also look at initiatives underway at the moment to prohibit the import of settlement goods and services to other countries via Israel. So Maha, I'll hand over to you.
Thank you, Eamonn, very much, and for Sadaka for organizing this event. And of course, thank you to all the distinguished audience for making the time to hear us and meet with us today. I would also like to take this opportunity to express deep gratitude for the Irish people in all of its constituency for their principled support for the Palestinian people in our struggle for liberation and justice. When the world turns its back to us as Palestinians, we still see the glimmers of hope radiating from Ireland. And in recent months, we've seen the world turn its back to us a lot, and Palestinians have been increasingly mobilizing against all forms of oppression manifested in Israel's settler colonial project in Palestine. Palestinians have escalated their resistance to Israel's premeditated plans to remove them from their lands and homes through their ethnic cleansing and dispossession, as we continue to see today, 73 years later since the Nakba in Jerusalem, in Nablus, in the Jordan Valley, in the Naqab, and elsewhere across Palestine. And these cities and villages that I mentioned only represent a microsome of Israel's attempt to create irreversible demographic facts on the ground. They are also telling to Israel's imposed reality of fragmentation on the Palestinian people, of institutionalized discrimination, persecution, and oppression of Palestinians. And since its establishment, Israel has orchestrated an inherently discriminatory system premised on racial and ethnic grounds to empty the land from its indigenous people by forceful, harrowing means and in creating a coercive environment. All of this to facilitate the settlement of Israeli Jews, just as we see today rapidly happening in the West Bank and in Jerusalem. These have all further cemented annexation and domination of Israel in Palestine. So now the reality is that there are more than 304 Israeli settlements and outposts that are dissecting the West Bank and East Jerusalem. They're disrupting Palestinian territorial contiguity with immediate and adverse impacts on Palestinian social, economic, cultural, civil, political rights, and preventing Palestinians from realizing their right to self-determination. There are hundreds of thousands of Israeli settlers living and working in these settlements, establishing businesses, industrial zones, tourist sites, vineyards, farmland, packaging houses, and much, much, much more on occupied Palestinian land for the benefit of the Israeli settler economy, which we should remember that it continues to be part and parcel of Israel's economy. And in addition to relying on political, financial, and military support from the government of Israel, these settlements are also legitimized and able to prosper because of business relationships and activities with corporations. Many of these, they are domiciled in Europe, but also because they are able to access markets across the world, including in Europe and the EU. And it is not and should not be acceptable morally or legally for products and services made in illegality and that are directly linked to war crimes and grave violations of land appropriation, destruction, and pillage, among many others, to enter international and European markets and be presented for consumers to consume. And the recent escalations in violations and the ever-increasing expansion of settlements are direct results of the pervasive impunity granted to Israel by the international community. It is therefore a very critical moment for the international community to take serious measures to put this cycle of impunity to an end and to translate all statements and all obligations of third states into concrete actions. It is now urgently needed that Ireland, together with other like-minded states in Europe, demonstrates its commitment to its international responsibility of non-recognition and non-assistance for Israel's illegal actions and wrongful acts, and cooperate with the rest of the international community to bring it to an end. And in this respect, the recent Irish motion on annexation is a very, very welcome and important step. And we do hope that you will continue to work with the Irish government to build on this motion and urge it to take the necessary concrete actions, including by banning all products and services originating from illegal settlements as part of Ireland's positive and customary obligations under international law. And as Susan mentioned, one possible way to do this could be through the enactment of the Occupied Territories Bill. Ireland, together with like-minded states in Europe, could lead the EU to ban trade with illegal Israeli settlements once and for all. But until a ban is in place, Ireland should continue and intensify its efforts at the Irish and EU levels in indicating and labeling the origin of products from Israeli settlements, building on the European Commission's interpretive notice of 2015, relevant rulings from European courts and the Court of Justice of the European Union, and in accordance with international law, including the Fourth Geneva Convention. And of particular importance and critical at this time, although I know everybody's preparing to go on summer holidays, but following the adoption of the Irish motion on annexation, it is very important that Irish parliamentarians do engage with their counterparts across the EU, particularly in Belgium, Portugal, and the Spanish state. And this is particularly important because we know that there are currently different initiatives that are being discussed within their political parties and at national parliamentarian level. So it would be very important for Irish parliamentarians to explain this motion, how it aligns with Ireland's duties and responsibilities under international, EU, and Irish laws, and to encourage them to take similar actions, to urge their governments to adopt stronger positions and to take meaningful actions to counter Israel's annexation and settlement expansion. This is also particularly relevant now because we're at a time when the EU continues to be unfortunately divided internally on Palestine and has also limited itself to statements of condemnation. So we do need Ireland through its government, through its parliament, to continue sending strong signals that there are countries that are willing to take the necessary action in the face of injustices. And in this respect, it is also important for Ireland to support international justice and accountability mechanisms. In addition to what Professor Lynk and Dr. Susan have already mentioned on these fronts, it is equally important that Ireland, together with other member states at the United Nations, pursue the implementation of accountability resolutions adopted by the Human Rights Council, as well as recommendations of all the UN investigatory mechanisms on Palestine. Relevant to this as well is the UN database of businesses involved with Israel's illegal settlement enterprise, which was mandated by the Human Rights Council in 2016 to be updated annually. And after the list of the 112 Israeli and multinational companies was published in 2020, the UN Office of the High Commissioner in Geneva claims to now have budgetary constraints that prevent it from updating the database. But just yesterday, 130 members of the European Parliament and national European parliamentarians, including from Ireland, sent a joint letter to EU member states calling for political and financial support to the UN database and urging their governments to request that the High Commissioner give a clear timeline for the release of the annual update of the database. And in this respect, we really do hope that you will continue to advocate with the Irish Ministry of Foreign Affairs and align with European colleagues to support the mandate entrusted by the Human Rights Council by all means possible. The database itself is important. It's a groundbreaking tool that is needed to address the lack of accountability for corporate involvement in violations and crimes associated with Israel's illegal settlement enterprise directly linked to annexation of territory. The database has already had positive impacts. Just in late May of this year, for example, the Central Bank of Norway decided to exclude 2 companies for their activities with Israeli settlements, one of which was listed in the UN database. More recently, this last June, the largest Norwegian pension fund, KLP, decided to exclude 16 companies, all of which were listed in the UN database for their links with Israeli settlements. And in addition to all of these, it is also important that Ireland utilizes its seat at the UN Security Council to continue advocating for accountability, to safeguard the essence of relevant UN Security Council resolutions, including 2334, and to work with member states to ensure its implementation, namely distinction and differentiation in economic, diplomatic, and all relevant dealings between Israel and the occupied Palestinian territory. And I would reiterate Susan's recommendation about encouraging Ireland to request an advisory opinion from the International Court of Justice on the illegality of Israel's prolonged occupation, colonialism, persecution, and apartheid, as also recommended previously by UN-mandated bodies. Ireland should also join the growing voices at the United Nations, whether in Geneva or in New York, calling for the reconstitution of the UN Special Committee Against Apartheid and the UN Center Against Apartheid to investigate relevant Israeli practices against the Palestinian people. And at the European Union front and the Europe front, We also hope that Ireland will continue to use its voice there and within the EU to urge for a serious assessment of the legal consequences of Israel's annexation, settlement expansion, forced displacement, and transfer of Palestinians, as well as other associated grave violations and crimes, and to accordingly develop a list of countermeasures to be implemented by the EU and member states in line with their obligations under international, European, and national laws. And here it is important to remind that Israel has long extensively annexed Palestinian territory and the occupied Syrian Golan without one practical reaction from the international community against this prohibited act and war crime. Of course, besides the theoretical ones that the UN General Assembly and other UN sees, but nothing concrete came out of these. And as Susan mentioned, meanwhile, there has been immediate responses to Russia's annexation of Crimea and the introduction of restrictive measures and sanctions against individuals and entities since 2014. And yes, Israel is not above the law and should not be above the law. The EU must stop its double standards and selective approach when applying the law to Israeli annexation and other violations. And we surely count on Ireland to lead the way. We also hope that to see Ireland mobilizing within the European Union to call for the suspension of certain agreements of EU-funded projects until Israel complies with all its obligations under international law, and to push the EU to review and downgrade existing trade and cooperation agreements with Israel based on legal necessity and commitment to relevant laws, and to also impose travel bans and freezes of assets on settlers and settlement leaders and other individuals associated with Israel's settlement enterprise. These are people that are directly linked to, that are facilitating, maintaining an illegal entity. And at times they are the same individuals that are on the ground perpetrating grave violations and international crimes against Palestinians. They cannot continue to enjoy unconditional EU privileges, including in access, travel, and so on. And we hope to see that Ireland also work towards preventing Irish and European companies from operating in and trading with Israeli settlements and from contributing to their maintenance and expansion. To make use, urge the EU and different institutions at the EU level to make use of the new EU human rights sanctions regime to hold Israeli perpetrators of grave violations and crimes to account. And lastly, we hope that Ireland will mobilize within the EU and at the international level for an arms embargo against Israel and by the EU and member states and other UN states. And I understand that these recommendations are not the easiest to process or implement given the immense political pressure, but they are all rooted in international law and are very legitimate asks. However, we can also all acknowledge that Israel will not end its colonization by choice. It must be required to dismantle its occupation and its apartheid. And right now, the Palestinian people are revitalizing their energy to challenge the system of oppression, as you continue to see on media, on social media, and the different protests that are taking place across the entirety of Palestine. And while we do so, we continue to look to Ireland to lead and mobilize the international community to take meaningful actions to support the quest of the Palestinian people for liberation and realizing their inalienable rights. Thank you very much.
Thank you very much, Maha. And thank you for reminding us of the Occupied Territories Bill, which is still there within Dáil Éireann, and hopefully can be moved forward at an appropriate time. I also note what you said about the need for parliamentarians to explain the Dáil motion and to encourage other parliaments in Europe and outside of Europe to follow that path. The UN database and issues around no budget being available. I mean, you know, everybody knows that often if you want to bury something, you know, just say, well, there's no money available. But in this case, that's not going to happen. It will not die for want of money. I'm absolutely certain of that. and also what you say about sanctioning settler leaders and settler organizations. And many of these organizations are actually listed as non-governmental organizations in the US and in European countries. And as such, donations to these organizations elicit tax reductions and tax benefits, which, when you realize that these organizations are part of the engine of occupation and annexation, it's quite shocking that citizens in many countries can benefit from this through their donations. So, right, so that's our three speakers, and there's a huge amount there. So just in case you thought that there was nothing that could be done, that there was no law behind sanctioning Israel or responding to Israel's 54-year occupation and its ongoing annexation of Palestinian territories, it's now clear that there is a wealth of opportunity there, a wealth of law, a wealth of possibilities and opportunities. And in the report which we will prepare, we will make sure that these are outlined in some detail for you. So we have about 15 minutes or so if people would like to put any questions to Michael, to Susan, or to Maha in relation to anything they've said, or indeed if there's anything else in particular related to this that's on your mind. So the floor is open to yourselves. Just do the usual, put up your hand or literally just unmute yourself and begin to speak.
First of all,
go ahead. Thank you.
Yeah, I would like to thank you, Eamonn, Marie, and all the Sadaka team for organizing this event. I would like to thank as well Professor Michael Lynk, Dr. Susan Power, and Maha Abdallah for their strong presentations. I mean, all the information that I heard today, it's, you know, we need some time to absorb it. It reflects how the international community really support the issue of Palestine, the violation of international law in Palestine, the annexation, colonization, and mainly it's the occupation. All what I heard today was really excellent, and I'm sure that they spend lots of time to prepare it, and however they are really absorbed in their mind and backgrounds. I have really one question. For the past like 54 years since the occupation of Palestine, the international community supports the Palestinians, and every day there are increase of these supports reflections around the world. Maybe during the last aggression against Gaza, we saw many protests. However, it was the COVID and the restrictions, but we still see so many people around the world support the Palestinians, support the Palestinian rights. My questions, like, you know, without going for a long time, I mean, my questions, why with all this support, we still couldn't put any sanction on Israel, or at least, like, you know, the international, like the UN or the EU, they didn't really get any concrete measures to end this occupation. I mean, I'm just asking myself for the past, like, you know, since I become aware of this occupation, I'm asking myself, the Palestinian believe in their rights, and the international community as well, they do believe, and every day we attend seminars, and we go to the human rights organizations, the UN organizations, and everything that I find, it's in support of the struggle of the Palestinians. I have one question for all the people who attend this gathering. Why Israel continue its occupation, its violation to the international law? I mean, there is no mechanism for sanctions or for punishment, or I don't want to talk about even sanction or punishment. Why the occupation, the international community couldn't force Israel to end occupied the Palestinian territories? if, like, in 1967, there was a resolution to say that these occupied territories, it's 67, including East Jerusalem. This is my question.
Thank you, Gilan, and thank you for asking the difficult question from the very start. So would any of our panelists like to pick up on that?
Let me make a brief
Michael.
start on that, Iman. You saw at the beginning of my presentation, I included quotes from a very recent article, a remarkable article by Ban Ki-moon. His predecessor as UN Security General Assembly, Secretary General of the United Nations was Kofi Annan, and he wrote a remarkable memoir in 2011, 5 years after he had been out of office, reflecting on his time as Secretary General. And he pointed to what I think is probably one of the primary sources with respect to why there is such paralysis in the international community. He says, quite bluntly in his memoir, and I'm quoting, "At the 11th hour, the Americans took over the process and tilted the framework towards the Israelis. I witnessed once again the unhealthy possessiveness that Washington has of the Arab-Israeli peace process." I think contained in that short paragraph probably is a long thread going through the history of both the occupation and what went on even before 1967 as I talk about the paralysis. Obviously, the United States has a veto power at the Security Council. The figures I understand is that since 1973, the United States has vetoed 31 resolutions with respect to the Israeli-Palestinian conflict, all of them critical of Israel's conduct of the occupation. No other member, none of the other 4 permanent members of the Security Council has voted against or vetoed any resolution at the Security Council with critical of Israel's occupation of Palestine. And what that means, in effect, is that when it comes to issues like the settlements and the various peace processes that we've been involved in since the beginning 30 years ago of the Madrid-Oslo process, it's meant that by and large, the organizing principles for international peace initiatives have been based on realpolitik instead of international law. Yes, the settlements, yes, Jerusalem, yes, the refugees are listed among the final status items to be negotiated, but there's no framework provided. The international law and the international community has a rich agenda, if you like, that all of these issues, the refugees, the settlements, the annexations of East Jerusalem, Palestinian self-determination, all are to be determined on the basis of international law. Israel, with the support of the United States, bluntly, has been successful in removing international law from the framework of the peace negotiations over the last 30 years. Every single peace initiative, comprehensive peace initiative, brought forth by an American president beginning with Bill Clinton in 2000, has sidelined the issue of settlements and said that settlements are to be discussed by the parties themselves, ignoring what Ban Ki-moon says in the article I had cited, of the vast asymmetry of power between the two. When you have parties at a negotiating table which have such different levels of economic, military, and diplomatic power in negotiating, the only equalizing factor has to be international law backed up by the international community. So as long as that inequality in the bargaining table exists, as long as Israel is able to insist that the negotiations will proceed, as they say, without preconditions, i.e. no reference to international law, we're going to see a Groundhog Day repetition of failed peace initiatives. Only when international law is at the cornerstone and is the framework for negotiations will there be a hope for a positive path forward.
Thank you, Michael. And I've heard you previously mention Barack Obama and something that he had in his memoir. I can't quite remember the detail of it, but it's similar to what you say about Kofi Annan.
Yeah, and what he said, I'll be very brief. He in parts of his memoir that was released last year, he gives a very standard American-centric view of the Middle East peace process. But at other times, he's quite blunt and says that virtually every country in the world has accepted that Israel is an illegal occupation of the Palestinian territories. And he goes on to say, look, whenever we raised during my 8-year administration issues of human rights in China or in Iran or in other places, the answer our diplomats always were faced with, well, what about Palestinians? And we had no answer. He basically said with respect to this. You know, sometimes I wish that leading international figures would read their presidential or secretary general memoirs before they became president and before they became secretary general. They may be taking a lot wiser steps.
Okay, so rather than invite Susan and Maha to comment on Gilan's question, well, just in terms of international law, hopefully the current ICC investigation, if that proceeds, even though it may take a number of years, may just be the issue that tips the situation back towards international law being somehow at the heart of it. But we will see in time. So, Vincent.
Thank you. Thank you. I speak as an interloper, so thank you for allowing me to speak. I'll be very brief. My question is about the Occupied Territories Bill. I'm impressed by all three speakers, naturally, and by the Ambassador of Palestine. Thank you for intervening. But my question is about the Overseas Territories Bill. I remember that the Irish government at one stage said it couldn't act without not only consulting the European Union, but without the permission of the European Union. And that's disputed because there are provisions of public policy which would enable Ireland to act on its own if that was Ireland's decision. So my question is, can that be addressed? I know there's a legal opinion on the issue which has addressed it, but can it be addressed politically now that Mr. Coveney has taken the step of acknowledging that settlements equal annexation? And I'll just add one other remark, which is I strongly endorse those who have advocated recognition of the state of Palestine alongside Israel. It's something we try to do without great success with Mr. Johnson over here in the UK. We'll keep trying. And we'll also keep trying on the issue of preventing Israel from benefiting from its annexation policies. Thank you.
Thank you very much, Vincent. And we all know that you're an interloper from County Limerick, so that's not too far away. Susan, would you like to pick up that one?
Yeah, there was a number of Attorney General two Attorney General opinions that Ireland didn't have the competence to prohibit the import of settlement goods and services. And I suppose like our position would be that there is a public policy exception, like even within the Treaty of the Functioning of the EU, that potentially we can bring this argument into. My understanding is that the main crux of the issue is whether that applies, whether states can trigger that for situations extraterritorially, the public policy exception. And I suppose at this stage, like we have also three very compelling legal opinions, like one from the late James Crawford in relation to the international, that international law is no impediment to the progress of an occupied territories bill, or the prohibition of the import of settlement goods and services. And there was also an EU law expert, Tadis Trickamus, who had also gave a very extensive legal position from the basis of EU law in favour of this public policy exception. And then in relation to constitutional law, we had Michael McDougall, who's like a very prominent lawyer here, who'd also given a legal opinion on that there was no constitutional bar. So like we have like very prominent and substantial 3 legal opinions for, and maybe 2 legal opinions against, counterweighting this. And I think at this point, it would be best for the Dáil to progress the bill and leave it to be an issue that is addressed at the European Court of Justice if there needs to be a challenge. But that being said, like in the meantime, there has also been a case that was the result of the Citizens Assembly initiative. So there was a Citizens Assembly initiative also that the Commission to put as an agenda item for the Commission to prohibit the import of settlement goods and services into the EU. And as a result of that case, which transpired quite recently, it arose that it wasn't a competence of the EU Commission argued that it wasn't the competence of the EU to put forward, to propose bans such as this. So I think we also need to, at this stage, scrutinise if it's not an EU competence, then that brings it back to the state parties. Then it's for the state parties to progress potentially these prohibitions. And again, like we would emphasize that this type of prohibition is Ireland's obligations under existing treaties that it has already signed, like the Geneva Conventions. So this is very separate to the type of sanctions and trade restrictions we were talking about earlier. So I think the ideal situation is for the Occupied Territories Bill to be fully supported all the way through as Irish legislation. And if there is a need to challenge that it would be challenged later at the ECJ level. But at this stage, I think there's a very compelling argument that the public policy exception actually does apply to Ireland, and Ireland could actually progress the Occupied Territories Bill. I just want to add one thing to the previous conversation that was had around the US and the US being such a bloc. You know, I think as well, like just in terms of Ireland's political relationship with Joe Biden, you know, and his Irish heritage and its roots, it's really incumbent on Ireland to stress, you know, and to really push for and to stress at a US level, like politically, the importance of working on Palestine and the importance of working to bring this occupation to an end, you know, and that's a responsibility on everyone in Ireland to use those very key lines of communication that we have in the US to advance Palestinian rights.
Thanks very much, Susan. It's about 3 minutes to 5, so we had promised to finish up at 5 o'clock. So I think we've time for one final brief question, if anybody has one. Okay, well, listen, if there is no further, Conán, yes.
Thanks, Eamonn.
Yeah.
Just to introduce myself, Conán Ó Brion is my name. I'm a political director of the Labour Party, for anybody who doesn't know me. Delighted to be here, and thanks very much for the presentation. Just two questions that I'd have. First is at a European level, and just to note that we have written to our Party of European Socialists, of which we are a member party, and asked them to write to all parties in all European member states with the text of the motion that was passed by the Dáil, to all our sister parties effectively around Europe, asked them to pass similar motions in parliaments, in other national parliaments around the European Union, just to let you know about that. I suppose the question I have is that what the conversation keeps coming up around is that the weight of the law is on the side of the Palestinian people, the weight of international law, or the weight of realpolitik, unfortunately, is not, and that's due in large part to the efforts and effect of the United States policy, consistent policy for a very long time. And I do note, though, that I remember when I was studying the conflict myself in college, that really that was all being driven in large part thanks to the lobbying efforts of the American-Israeli Political Action Committee in the United States, AIPAC. I'm sure you're all aware of them, and the money that they effectively send to candidates who are contesting elections at all levels in the United States. And that is actually a huge source of the support which drives American support for Israel, notwithstanding all the other issues and obviously the ties that bind. So my question is, I note that there are certain democratic people in the United States, I'm thinking of Rashida Tlaib and Ilhan Omar, who are actually starting now to speak out in support of the Palestinian people. And if there's hope there that perhaps that support for the Israeli people could be neutralized as a result of that effort, or if maybe, Gillan, if you know, if there's any efforts underway on behalf of the Palestinian missions overseas to try to, I suppose, match or mirror the political support which Israel is engendering in the likes of the United States, that would really help to maybe turn the table a bit. Because really this is what this conversation keeps coming up towards. As I said, the weight of international law is most definitely on the side of the Palestinian people and Palestine. And it really comes down to realpolitik and the dynamics of US politics. And I'd just be very interested to hear your views on that. Thanks very much.
Gillan, would you like to pick up on that?
Thank you, Conán. To be honest with you, if I missed it for a little bit, your questions, I just wanted to maybe to rephrase, if there is any initiative come from the Palestinian Authority around the world in regards to the international law. I was right. This is what you meant.
No, sorry. It's in relation.
Maybe will I just interpret it for you, Conán?
Go for it.
Yeah, it's just more. In the United States, do you detect any
because
real
I
change?
was right.
And is there any possibility? I think the Palestinian voice is getting stronger, linked to other progressive movements as well. Is that something positive and solid, which ultimately will transform things? I think that's it, Conán.
I apologize, Conán, because I was just writing something to Professor Lynk about his response for my question, and that's why I missed some of your questions. Actually, we're recently, as everybody knew, that there is a little bit of restoration of our relations with the United States, like reopening the general consul, the consulate general in East Jerusalem for the Palestinian, and this is as well. It's good for us, a Palestinian, to bring back this kind of relations that used to be between us and the United States. That was freezed during Trump period. As well, there is a news of reopening our mission in the United States. The opening of our mission in the United States will give us as well a kick for restorations of the relations with the Americans, especially when you talk about the public diplomacy, the relations with the engagement of the mission or our representation in the United States with the people as well, because this kind of relation as well is very important, and even the official communications with the Congress, with the officials in the United States, this will give as well as a kick. The UNRWA aid as well that was cut during Trump period as well, it's coming back to. Hopefully it's coming back to normal, and the U.S. aid to the Palestinians in East Jerusalem and for the Palestinian Authority as well on its way to be back to its normal. All these signs, it gives us a sight or like hope for I know that the relations before Trump era, at least the communication could open doors for the Palestinians. But now, I mean, hopefully that with the new administrations and with all these things coming up with the relations between the Palestinian and the United States, hopefully that it will open up the relation again. And I mean, yesterday I the demolitions of this Palestinian Americans, for the first time, the Americans, they were condemning the demolishing of the house. However, hundreds of Palestinian establishments and homes were demolished all during the last decades. This is the first time for the U.S. administrations to come and condemn this demolition. This is give us I don't want to say a hope, but it will open up some closed door that for the past 4 years we need a little bit of time to restore these relations. But it seems that the American administration is easing the ways between us and them. Usually every year during the General Assembly meetings in September, there's always a chance for meeting the President of the United States and President Mahmoud Abbas. We hope as well, if this will come back again to its norms by September, this will open up as well another dimension for this relations between the U.S. So all these factors, I guess it gives some hope. However, as long as there is a great support of the occupation of Palestine, things will be from our side. We have to push it in a different way. As I see that with this international support, this will help us, especially we saw this support recently. It's increased and it's taken different ways. The annexation motion that was adopted here or passed by the Irish Parliament as the first European Union state to take such action as well will empower our position while we're talking among the Europeans and in the United States. So all of these factors, all of these signs, we hope that it will give us a push towards the relation with the United States. And as Professor Lynk said that, even if any future negotiations between us and the Israelis, we should insist to have something to be based on the international law. I think this is something that we need to work on, and with the support of all those people who around the world leading with the international law and human rights organizations would support us in this. I think if we manage to put this as for any future negotiations between us and the Israelis to bring the international law to be there, I think as well it will give us a very strong position in any future negotiations and with the relations with the United States.
Okay, Gillian, thank you very much for that. Maha, you haven't come in on any of the questions or answers, so I'll give you a minute or two, and yours will be the final contribution, if you have any thoughts in particular on Conán's question.
Thank you, Eamonn. Not particularly directly related, but maybe slightly on the importance of influencing the narrative and the discourse. And I think where we are right now with the question of Palestine, this is of particular relevance and importance to. So even if all our efforts are not being directly translated into immediate policy changes and decisions at the highest levels of the UN or the US or the EU, but it's still relevant and very much needed to talk to as many politicians as possible, but also as many people as possible, civil society activists and trade unionists and parliamentarians, and so like all different categories of any population everywhere about the struggle in Palestine, about justice mechanisms, about what can be and should be done. And again, this is all part of influencing the wider narrative and the discourse, which has come under a lot of threat, under a lot of attempts to become obscured, to be changed, and to be diverted from what is really happening on the ground.
Eamonn, you're on mute.
Thanks, Marie. And yeah, that's very important, Maha, and influencing the narrative. And I think we will all continue to do our best to influence the narrative. So listen, thank you all very much. We're a little bit over time. So to Michael, to Susan and Maha, thank you so much for your time today and all of the preparation that you put into this. We really appreciate all of your work. Ambassador Gillan, thank you. Vincent, thank you for joining in from London. And to all of our political friends and NGO colleagues as well. And we wish you a very relaxing and peaceful summer, and hope you'll all come back with renewed energy and enthusiasm in the autumn. And we will have a report ready for you with many of the measures that no doubt that you will ensure that Ireland, and by extension our partners at an international level, take in the coming months and years to ensure justice and equality for Palestine and its people. So thank you all very much indeed. And thanks to Marie as well for looking after the technology. Thank you and all the best.
Thank you, Eamonn, and everybody.
Thank you very much.